Okay, abusia yabemma kwa ba sonko so edeba Ghana politics avenue so abusia yembunra yensemu EC is said to be cited for contempt for disregarding High Court order on Kpandai seat. Abusia Kpandai seat court really say yenkonkoye rerun of election. Abusia Electoral Commission enye na adwen say ordinary bema court na sisi anu yeba be cite Electoral Commission Mahama Mensa and for contempt. Enka by now, enka say Electoral Commission so a application as let be babon say and as or announce the rerun of elections of Kpandai, but Electoral Commission so enye na adwen say obedi court in the ruling. So mommy yanko na yanko ti ensema e course unsubscribe here, subscribe, like na share ma Akuffo so answer into me enka bi. Aha, Ghana politics avenue so medamase.
Is this? The Electoral Commission was a party in this matter. They were the second respondent. We have seen with some disquietude the attitude of the Electoral Commission in complying with the court order. And they didn't do so in Jachikwesi. In Jachikwesi, as soon as the court order was granted, they issued the notice for re-election, for rerun of the election. In this one,
but
they've been hesitant for over a week.
Before EC.
No, you were a party, so you need no notice. When you are a party to a matter, you need no notice. You were in court when the court orders were issued. The court says rerun. Who has the mandate under the Constitution to order a rerun?
Is it not fair enough to say that maybe they also waited?
You speak of fairness. Window? Do you know who we were holding the seat? We were going for re-election. The Honorable Insala Wakpal, he was the sitting member of Parliament. 2020. No, 2024.
Yes.
He went into the election. They used this process to deny him a re-election. For 10 months, 11, he's been very patient. The party NDC will be very patient. So when people talk about fairness and the greater damage will be caused to Nyindam who has stolen our verdict, we should be crying for Nyindam. What about the person who was denying the opportunity to continue in office?
But in this case, if you say stolen verdict, the EC in court defended that, well, what you presented were minor arithmetic errors and that they did not influence the outcome of the election.
You see, thankfully, the EC is not the court. The EC is not the court. Are you aware that Tema Central was declared for us? The EC took the ballot boxes, brought it to Accra and declared it for the NPP. Are you aware? Using a different returning officer. Are you aware that in Fantiakwa South, they brought the ballot boxes from Eastern Region, brought it to Tesano and declared it for the NPP?
Is that the reason why you're calling for the head of the EC chair?
I don't know about that. I haven't done anything. But I'm telling you that the EC is not credible. Some of their officers are so compromised. Even when they see green, they will say it's blue. Do you understand? So the EC, that is why they were cross-examined in court. And the court saw through the kind of evidence they led. Why hasn't the EC issued the notice for a rerun? What is preventing the EC from complying with the court order? The court ordered that it should be done within 30 days. We've already lost 7 days. So now we have only 21 days. When is it going to issue the rerun order for the parties to comply, go and conduct their elections and go through the processes of filing a nomination for the election to be done within 30 days? But you see, because they are supporting one side in this battle, and that is they are supporting the NPP side. Otherwise, the EC...
You mean EC is in bed?
I am directly accusing
Do you have evidence?
The evidence is that they have refused to act in accordance with the court order for the past 7 days.
But they are still within the 30 days.
But I'm asking you, right? When the court says order a rerun of organize a rerun within 30 days, you have already lost 7 days.
So EC could be...
No, within the terms of CI 127, the processes that you must go through for even filing is so tenuous and tedious that you can't even do so successfully within 21 days.
But in fact, they did it with Ablekuma North. I mean, Ablekuma North, they were able to organize the rerun of the 90 or 14 polling stations.
Do you know who triggered Ablekuma North? It took me. They refused to order, to actually ask for the rerun. to organize the rerun. It took me to file a question directed at them to come to Parliament. When they came to Parliament, they were all over the place.
So are you going to are you going to file another question for the EC to come to Parliament?
No. I think that the EC should be cited for contempt of court, for obviously glossing or disregarding the High Court order emanating from the High Court Tamale in this matter. Because look, the EC has taken sides in this matter. That is what me.
Okay.
Me. That is the position and even the top echelon of my party have come to, because they have taken sides.
Well, I mean, after this short break, I'll be asking Justice Abdullahi whether at this point Kpandai should say that, well, we don't have an MP. Now come back to you to now go to Justice Abdullahi. I was asking if at this very point, looking at the context and what we've seen so far, Kpandai should actually consider itself MP-less, if there's any word like that.
Kpandai still has an MP, and I think when the issue of Jachi Christine came up, I remember making this suggestion that perhaps the way and manner he was booted out of office was clearly wrong, was unfair, and he should have been favored us. And so I can understand the emotions my brother Roxanne is displaying because of that past. However, I think that as part of the reset agenda, perhaps we should be rethinking how these issues are dealt with properly, so that it takes the emotions out of the context. Then we deal with the matters as they unfold. And some of the reforms that I proposed at the time, which I still believe is the right thing to do, is to firm up this idea that until a final determination is made by a court of competent jurisdiction, ousting a member of parliament from office, under no circumstance can that member of parliament, whether by an interlocutory application or by any other form, be removed from office. I do not think that, because it doesn't advance the works of parliament. It doesn't advance the cause of our democracy. I do admit the wrongs that was occasioned by the Jashquation case. And I condemned it, and I still condemn it. I still stand by that. But I do not think that a repetition of that, either directly or indirectly, or in any form or shape, is the way to go in building a stronger and a better parliamentary democracy. I think we need to rethink these rules here. But having said that, I need to affirm that indeed the people of Kpandai still have a member of parliament. He has not been removed yet. No new member of parliament is in office at the moment until the communication between the court to the speaker and the electoral commission take effect. And then a new election is conducted. Until that period, we can't say that he has been removed from office, because you need to execute the judgment of the court. And the execution process is what has commenced at this point. But of course, we're all aware of the steps that have been taken by the MPP to stall the execution. So until the execution is effective, no one can say that the people of Kpandai do not have a member of parliament. It can't be possible. But let's remember the intervention, either legislative intervention or any other form of intervention to sanitize these issues, so that we avoid I do you in future, which is usually run by emotions.
Well. So, Mr. Dakwe, in this case, would you still believe that? I mean, Mr. Nyendam is still a member of parliament for Kpandai, even though you have filed a review at the Supreme Court and a stay also at the High Court.
Yes, of course. He's the member of parliament for the good people of Kpandai, and there's no question about that. My brother should calm down. In fact, if I were in the studio, I'll just do this to him and you know that.
Room?
My roommate is...
Our cat call is room.
Oh, okay.
My roommate is he's heating up. But it's okay. I don't think that we need to push our democracy to that level. Because see, I can see. And you know, this is not the first time it's making reference to Jatikwesi. Last week, we were in the house. We were talking, you brought Jatikwesi. What do you put into Jatikwesi in this house? This is not even... And so I can see that a lot of the things our friends from the other side are doing are just, you know, emotions, and sometimes they want to retaliate. But I think that it's about time we move from that kind of politics. We have to. And for me, I believe that we are the young men. The future of our country largely depends on the young men, you know, in this generation. And so, if you we should elevate the conversation. We should, you know, do away with, like I said, the retaliatory politics. But you see, clearly the case is still in motion. We haven't exhausted all the processes. There is the application for stay. There is the application for judicial review. You know, all these are legal processes that must run their course. I don't think that it is now for my friends to say that we will not allow him to come to the just because of Jatikwesi. I mean, look, maybe the effect is the same, but the circumstances are quite different. And so you should allow who has to remain. And I don't think it's okay at this point for my brothers to be saying that the Electoral Commission, you know, they support NPP. I think that we've gone past that. Look, the Electoral Commission clearly showed its independence when the Akwatia issues came up, especially on the issue of whether or not the 24th December Gazette notification was valid or not. The NDC argument at the time was that the 24th December Gazette was a valid one. The EC supported them. The EC stood by them. Because at the time, the NPP was making a case that we should rely on the 6th January Gazette notification. The Electoral Commission said, no, we stand by the 24th December Gazette notification. You were in the same side, or you were on the same side. You know, so I believe that generally when the law and the facts are on the side, it is what it is. And on that time, at the time you raised that issue, the law and the facts were on your side. The Electoral Commission supported you. So if today the Electoral Commission is not supporting your position, it doesn't mean that the Electoral Commission is an anti-NDC. And I don't see why we are in such a haste. The judge has made a decision. The decision is being challenged. You are saying that no. We should go ahead and declare the seat vacant. Let's go and have an election.
Well, I have a question for you. In fact, if all these processes that you are talking about in terms of the reviews that you have filed and all of that, if we go through all of these processes and it still has to do that Mr. Nyindam or Honorable Nyindam has to actually vacate that seat, are you going to subject yourself to a rerun?
We are a country of laws. And we are law-abiding citizens. If we go through, we exhaust all the appeal processes, and the court's position is that the Tamale High Court is right, why not? We will do it because we are law-abiding citizens. There's no way the Supreme Court or the Court of Appeal, I mean, whichever one we're talking about, if the Court of Appeal makes a decision that the High Court decision is valid, we will go according to it, because if you are going through the appeal process, it will end at the Court of Appeal. We will subject ourselves.
You won't wait for the Supreme Court?
I say that if we exhaust all the appeal process, because the Supreme Court application, of course, it's that the Supreme Court is higher, but it is also so big that when the Supreme Court says that the court did not have jurisdiction and is wrongly assumed jurisdiction, everything that happened will be rendered null and void. And so there will be no need for us to go into the facts of the case, because the Supreme Court said that there was no case for the court to even assume jurisdiction, because you couldn't have brought that case after the 21 days. So if the Supreme Court makes that decision, there'll be nothing for us to discuss. It will be the end of the case.
When are you expecting decisions from the appeals court and also the Supreme Court?
Oh, my brother, I think this is not a question that I can answer. But I know that in the Supreme Court, the date for the date we are seeking, I think it's 16 December. But when it comes to the Supreme Court, they can change the dates. They will normally don't get the date you want. And I think the Court of Appeal probably is next week or so. Again, those two courts, normally they will determine their date. But when you are making your application before the court, you suggest a date. General High Courts, they stick with it, but Court of Appeal and Supreme Court is not so certain. So it is when they enlist the case and panel judges, then the matter will be heard. But I want to believe that the Chief Justice and the court will see the need to expeditiously decide these cases so that we can have some peace. In them. I will allow me to just make my point, then he comes in. Because he seems to be the non-politician here. Look, the NDC is just interesting. You see, my brother, we need to be very consistent in this country. You cannot approbate and reprobate. This 24th December publication, is what the NDC relied on. It formed the basis for causing the arrest and all of that. In fact, they made a police case against our brother Ernest on the basis that he was relying on the 6th of December, the 6th of January Gazette instead of 24th. So when the NDC went to court, they actually relied on the 24th December Gazette notification. Now all of a sudden, they are telling us that the 24th December notification is a supposedly Gazette notification that we are bringing. When you have brought this to court, in fact, the court pronounced on the 6th of January notification. And that is the reference I asked you to read. In fact, the court actually made reference to the 6th of January Gazette notification. So it's not as if the Supreme Court didn't know. The Supreme Court was aware. They had generously made a case out of that. It was. You can say that at that point it was our part, and the committee who was making the point that we should rather rely on the 6th of January notification. And the NDC was insisting that it should be the 24th of December notification. And the court agreed with the NDC at the time. Now, they don't want to rely on it. I mean, come on. How can we be this inconsistent? We need to elevate the argument in this country. We need to ensure that when we, and be principled, when you say A, we should continue to say A if we believe A is the truth. Even when we are going to be killed, let's continue to admit or let's continue to rely on it. Let us not approbate and reprobate. It doesn't help our political discourse.
No, Justice Abdullah, I mean, a cut-off point here is very important because we are looking at a statutory 21-day window that has been created in the Constitution. You have two, dates for Gazette. The first one came in on the 24th of December 2024, and based on what I'm seeing from the FEMA report, there's one also on the 6th of January 2025. Mr. Abdullah, in this case, with respect to this issue and the context we've created so far, which one should take, superior stage in terms of knowing where the cutoff point should be or the starting point should be in counting that 21 days, statutory, data has been provided in the Constitution?
Well, thank you. So I think with this question, you're asking the wrong question.
It's supposed to be to the EC, right?
Yeah, sorry. And I say this because before a particular new gazette that be made, there ought to be a reason for doing that, because you cannot just multiplicate gazettes. It's unlawful to have multiple gazettes of the same fact. So there must be a good reason for bringing a new gazette if it's in respect to the same subject matter. My understanding is that once there's a new gazette on the respect to the same subject matter, the earlier one must have contained certain errors which, if true, ought to have been disclosed, or some form of extenuating factor for which reason a new one will be done. If there is no basis for that, then you cannot even do the new one and much less justify the basis for using that one, relying on that one for the purposes of any argument. In which case, the earlier one will be the basis for counting. I think this should be it for that.
Okay, abusia we ne ensema ekoso e political highway so easy and I see am ye babe site no for contempt ayede ehonsem e de brem no majority chief whip ena e de sa ensem we etudwa e de mai unsubscribe ya subscribe like na share ma afofron so ensa into me enkabi Ghana Politics Avenue so benamase.